Welcome everyone to the IAPP web conference, User Consent in the Digital Age, sponsored today by Securiti. My name is Jordan Hardy, Programming and Speaker Specialist here at the IAPP, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. I also want to let you know that a recording of this program will be available in your My IAPP, My Purchases, My Recordings portal within 48 hours. So also, please feel free to post any questions you have for the panelists in the Q&A area at the bottom of the screen. And again, that recording will be available if you click on the icon at the top right of our website and then go to My Purchases and My Recordings. That's where you can access that. Now onto our program. I'd like to introduce today's panelists. Firstly, I'd like to introduce Beatrice Botti. Beatrice is VP Global Data and Privacy Officer at DoubleVerify. Welcome, Beatrice. Thank you so much for joining us. And can you tell us a little bit more about your current role and prior experience?
Sure. So I've been at DoubleVerify for about 2 years now. It's a company in the ad tech industry, but focused on verification, which tends to be relatively niche and not something that most people are aware of. But if you are in the marketing industry, you probably know about either the function or even the company. Before that, I was at a company called Virgin Pulse, which is part of the Virgin Group, and we provided wellness and well-being services as an HR benefit. So I have a background in health-related information, and then moved into ad tech recently.
Awesome.
Thanks for having me.
Yeah, so glad to have you back. I'd also like to introduce Rachel Glasser, CPO at Magnite. It's a pleasure to have you back as well, Rachel. Can you tell us a little bit about your background and your current role?
Yeah, sure. Thanks, Jordan. I'm Rachel Glasser, Chief Privacy Officer at Magnite. Magnite is a sell-side platform in the ad tech ecosystem space. And we basically make available inventory from publishers, CTV providers. We make that inventory available for buyers to buy and place advertising. Previously, I spent a lot of time on the agency side, more on the buy side and the creative agency side, within also ad tech, obviously. And here we are today. So thanks so much for having me again, and really excited to be here.
Yes, excited to have you. And then to run on our panel, we have Nigel Hawthorn, privacy spokesperson at Securiti. Nigel, can you tell us a little bit about your background and your current role?
Yeah, sure. So I work for Securiti, a platform for both privacy and data management. We look at sensitive data and help you manage it. And as you may guess from my accent, I'm based in the UK. I wrote a book about GDPR, trying to introduce it to IT people a few years ago. And I'm now, as you can see, the spokesperson for privacy in Securiti.
Wonderful. Well, we're excited to have this conversation with all of you, so I will hand it over.
Okay, so I'm going to introduce each of the slides here. So as you can see, user consent in the digital age, and everything is changing. We've had many discussions before we settled on the material for this webinar, and actually some of them went on for quite a long time because there are so many things that we can talk about. But what we decided was that we'd only talk about a number of areas here, just 5 areas and only really 5 slides, because what we want to do is have a free-flowing conversation. So as Jordan said earlier, if you want to join in, please type in questions into the Q&A box, and we'll try to bring those in during the conversation or at the end. And as you can see here, we're going to first talk about what's happening now. The digital world is in flux. There are so many things going on that actually it's very difficult to keep up to date with the latest changes. And then see what big tech companies are doing. They're not, of course, the only people responding to change and trying to ensure that they continue to be profitable in the new world. But they're going to be helping to drive all of us, and we need to watch and see what they're doing and be able to ensure that what we do ties in with the big tech companies. Then let's talk about consent, which of course is not the only legal basis for processing data, but it's the key one that people talk about so often, especially when you're trying to bring in new prospects and customers. I'll talk a little bit about how a consent management platform can help, but then we'll have some parting thoughts, some predictions, and this is the time for us to dive into your questions as you bring them up. So firstly, part one, the digital world is in flux. And Rachel, do you want to start off by talking to this?
I'd love to. Thanks, Nigel. So to sort of set some foundation for those of you who may not be quite as familiar with some of the things that have been going on, at least in the digital marketing sphere, I could level set a little bit. So first and foremost, we have the GDPR in Europe, which is probably one of the more restrictive data protection laws that has been put into force. And it's been about 4 years now since the law's gone into effect, and we've learned quite a bit from different enforcement, different regulatory authorities, different supervisory authorities throughout different countries in Europe. One of the things that was created as a product of the GDPR was an industry standard by which you can collect and pass consent through the advertising bid stream. And that's called the IAB Europe's TCF, so their Transparency and Consent Framework. This framework has been utilized for the last couple of years as a way for third-party advertising technology partners to register with the IAB, which is an industry body. You provide all of this information about your organization and how you collect and process data. And then you are now a part of this framework, and you can actually just pass consent or no consent signals through the bid stream. So you know when if you're a third party and you're not able to collect consent directly, you know when a user has consented to on the publisher page or in some other capacity. That was working very well until this past February, when the Belgian Data Protection Authority, the APD, I'm not going to try to pronounce the full name, when they actually ruled in an opinion that the TCF is incompatible with the GDPR. This was obviously quite a big deal because so many in the industry relied on this set of standards in order to pass through consent or opt-out signals through a very complex technical ecosystem. That's one of the big changes. So currently there's litigation ongoing, and there's been a proposed plan to make changes to the framework in order to make it more compatible and to fit more clearly within the different provisions of the GDPR. But the point is, this is still really up in the air right now because it is being litigated in court, and really anything can happen, and we haven't had approval yet, or the industry, I should say, has not had approval yet on whether the proposed revisions to the plan would be sufficient or satisfactory to the regulators. In addition, in Europe, we've got a number of different regulators, and I'm glad to see Italian's been added there. That's the most recent development, where we've had the French regulators, the CNIL, the Austrian regulators, the Italian regulators. Again, I will not attempt to pronounce it and butcher the names, but they have ruled recently that Google Analytics violates data transfer requirements and data transfer laws under the GDPR. So that is also sort of a big deal. So many companies, advertisers, brands, they rely on the use of Google Analytics in order to measure a lot of their marketing efforts and to be able to know where to put certain advertising dollars and to keep their marketing efforts somewhat efficient, cost efficient. So that's a pretty big ruling as well. That's sort of what's going on in Europe. So a lot of different balls in the air right now in terms of trying to figure out how to modify or adjust behavior. If we move a little bit to the US, we also have a lot of changes that are sort of, in process at the moment. The biggest one that's most pressing is probably the second. I think we may all be aware of the CCPA, the California Consumer Privacy Act, that went into effect about 2 years ago already, I believe, and that will be amended by the CPRA, the Consumer Privacy Rights Act in California, and the CPRA is currently undergoing its comment period for a proposed set of regulations. And why this is difficult to sort of plan for at the moment is because the regulations are just a proposal, they're just in draft form. everything can change. And so the way they're published today may not necessarily be how they get finalized in a month's time, let's say. We saw this happen with the CCPA, where the CCPA regulations basically called for all sorts of things, attestations from third-party data providers, as an example. And so companies ran around crazy trying to get all of this paperwork done, amendments to their contracts, attestations, only to land on the final version of the CCPA regulations, which actually did not require an attestation. So all of that work was sort of done for nothing, which is why I think a lot of parties that are in scope for the CPRA are going to kind of wait and see how these regulations get finalized before they make any substantive changes to their processes or their contracts. Some things to consider that we know will exist under the CPRA is sort of this addition of this definition of sensitive information. There are some additional user rights, including the right to correction. There are proposed pass-down requirements that we have to think about, proposed global privacy controls that it's not entirely clear what those mean or what that requires. So there are a lot of things that are sort of up in the air again in the US in terms of California. Not to throw more on the fire, but then of course we've got other state laws that will be coming into effect next year in Utah, Connecticut, Colorado, and Virginia. So there's definitely a lot going on and a lot that's put into question. The best we could do at the moment is review what is currently required, start to think about the things that you might need to do to change your business, and then go from there. So just stay on top of all of these changes that are coming. So sorry, I just talked quite a bit, and I'll pause there.
So actually, you remind me that with the IAPP, we did a CPRA webinar, which I'm sure is available on the website for replay. We did it about 2 or 3 weeks ago. So if you want to learn more about that, then feel free to click on that. Beatrice, do you want to add anything to that? Or do you think Rachel's covered the background?
Rachel always does such a great job. She could teach a class. The only thing I would add is sort of to pick on Rachel, the Italian privacy authority, it's called Garante della Privacy, since I am Italian, so I get to call that one.
Beatrice, I could never say it as beautiful as you. Yes.
I'm not going to do the Austrian one, even though my team is in Germany, so they're probably like not excited about my bowing out on that one. I will say that one of the interesting things is with all of these changes that are occurring globally, one of the big open items, at least from my perspective, and I think for a lot of the people that are attending today, is what's happening on international data transfers. And that's a hugely consequential question, which is still up in the air as well, but sort of came back to the forefront because a couple of days ago we had news stories out of Ireland saying that the Irish Data Protection Authority is prepared to shut down data transfers for Meta, which would be very consequential for the economy, for example. So that's putting a lot of additional pressure on, is the transatlantic data partnership going to happen? I'm always, Rachel and I talk about this a lot. I'm a skeptic to the extent that it wouldn't, because I don't know how the economy and the internet could survive if we were to shut down data transfers, but it is definitely an open question that I think a lot of people are thinking about, and it affects a lot of the decisions that we see here, in part the TCF, but the Google Analytics violations of GDPR are deeply and intrinsically connected to, can you transfer data to the United States? To what do you need to be able to do that legally? And interestingly, the United States is not the only country right now that's dealing with this adequacy issue. Israel is up for renewal of their own adequacy decision, and the IAPP published a really interesting article about it recently. But there's been a lot of talk about it because the way that the Israeli government has approached trying to solve the issue has been to publish sort of an executive order of sorts, stating that European data will be protected in accordance with the GDPR requirements within Israel, which essentially creates a higher level of protection for individuals who are not citizens, which understandably caused a lot of distress in the government and with experts in the country and even outside. And some people asking whether or not this is the path that the United States is going to have to take to gain that adequacy decision as well. And, I think that was not really something that was being contemplated when we were still actively talking about a federal privacy law. Things have happened since then that have affected those conversations. I really don't think it's a viable path forward. But it's definitely an interesting question. We're seeing a lot of different governments having to struggle with this, with the really strong actions coming out of Europe, which I think are admirable, but also I don't think that the fall of the currencies that we're seeing in the markets is wholly unrelated to the concerns around data transfers.
If I can say what I see it from the European point of view, is there's a fight going on between two types of privacy people, privacy purists and privacy pragmatists. And I think some of these violation points being made by some of the regulators are being driven by the purists who are perhaps in the ascendance at the moment. But I'm rather hoping that the pragmatists in the end will allow us to recognize that while we need to keep things safe, there are still ways to achieve that and give people strong privacy at the same time.
Nigel, that highlights a really interesting distinction, a cultural distinction between US court systems and European court systems, because the US court systems tend to have a focus on what are the real impacts of a decision. Meanwhile, traditionally, European court systems are very much about applying the law, and the government will have to deal with whatever the consequences are. But, that's a line of thinking that is fine most of the time, but I think the internet creates implications, and the digital economy that we really rely on today just makes that line of thinking a lot more tenuous when it comes to maintaining a viable economy.
Yeah, absolutely. So there's a lot going on, and there's a lot to watch out for. And I think that in your companies, you can say to people, we're still investigating, we're still looking at some of these things, we're paying attention, and of course events like this hopefully help people understand what's going on. So actually, let's move to part two. So what are the big tech companies doing to respond to all of this change? Who wants to start?
So I'm happy to jump in on this one as well. I think a lot of companies, especially tech companies, are making a lot of changes that are very consumer facing and that consumers, directly interact with. An example may be on iOS, asking the app not to track across other apps or while you're not using the app. That's an example. Now, whether those disclosures meet certain legal standards is a different conversation, right? But it's you could see that there are more concerted efforts to try to focus on privacy. I think in addition to the app not to track, we have this big motivation within the industry, partially because of the sunsetting of support for third-party cookies on Chrome, to establish sort of cookieless solutions, which I think are trying to be constructed in sort of privacy-friendly ways, whether they are cohorts or groups versus, profiled individuals. There are definitely a number of solutions sort of floating out in the ether, and working groups to try to hone in on some of these solutions. I touched on some of the changes coming from the state laws and this idea of like global privacy controls. And although that's more of a legislative dictate, there are already working groups and task forces within the industry to try to establish a standard and potentially a technological solution or resource to be able to enable something like a global privacy control. So we do see a lot of these actions coming out of the big tech companies. I think that's kind of important though, because so much goes through those companies. I think it's important to also understand how some of those controls may limit the ability to work more collaboratively across a full ecosystem versus within just a walled garden. There are a lot of pros and cons that come with some of these changes that are coming up. That's probably the biggest thing I would say. But aside from that, I would say all companies who would find themselves within the scope of these new data protection regulations and laws, or within the scope of some of the new decisions that are coming out, they should all really consider what they might need to change in order to meet these regulatory requirements.